said, my husband was coerced into a plea. The attorney wasn't ready for trial. Victim didn't want anything to do with the case. And there was no impact statement. Yeah, so that happens a lot. So I'm going to take it the first part, right? If he was coerced into a plea, we all know that if it was a complete plea bargain where he pled guilty and agreed to a sentence, he has no right to appeal, right? So he cannot appeal that decision. But you're saying he was coerced, therefore it wasn't voluntary. And so that can be challenged in an 1107 writ of habeas corpus as involuntary plea. Now, involuntary plea is usually tied to ineffective assistance of counsel, right? It doesn't have to be, but that's usually the way it's presented. And so if counsel didn't, investigate or didn't tell your loved one about a certain fact or something that was known in the case that would have impacted his decision whether to plead guilty or go to trial, you can assert involuntary plea. Now, if the victim, I think you said the victim recanted, or said that they wouldn't testify, and that happens sometimes, like in assault family violence cases, where you have someone even sign an affidavit of non-prosecution and they don't want to testify. They want to drop the whole thing, and the state's like, well, too late, too bad. You've already made a statement. We already have enough evidence against this client. Therefore, we're going to move forward. So you either plead guilty or we go to trial on whatever this is. That is, that happens all the time. Now, if you have a victim that recanted and it's some kind of sexual assault or something that can be proven that didn't happen, that could be worth filing an 1107 and asserting involuntary plea. It really just depends on the facts of the case, and so I can't give you just a determinative, definitive, like this is exactly what you should do. But it sounds like that would be your option, right? Involuntary plea via 1107 writ of habeas corpus.